New tonight, serious allegations against the Queen Creek Unified School District. ABC 15 has obtained copies of complaints from 25 teachers claiming they were punished for taking time out of the classroom, and that's protected by law. ABC 15 Sonu Wasu talking to the attorney now representing those 25 teachers and what school officials have to say about all of this.
I took FMLA leave due to feeling unsafe to return to the classroom with over 24 kids in my class and not meeting the state-suggested benchmarks to return. They are the words of a desperate Queen Creek Unified School District teacher, typed out in what is now an official civil rights complaint filed with Arizona Attorney General Mark Brnovich's office. She goes on to say, quote, "I was never told I would not be able to return to my own classroom."
The law says, we can't discourage people from trying to take FMLA.
Patrick Camunez is the attorney who now represents this teacher along with 24 others who have complaints against the Queen Creek Unified School District. At least 3 of those teachers now allege the district is violating FMLA and the Federal CARES Act family leave policies.
Those people that took those leaves are, they're not being allowed to go back to their classroom.
Under the Families First Coronavirus Response Act, employers can grant paid leave for an employee to take care of their health needs related to COVID-19 or to care for their family members. They are able to return to their previous jobs.
The law says it's the same or similar position.
And that's the catch here. These teachers say the district did give them their jobs, but they were told to move to a completely different school.
The law doesn't end just there. It talks about how, you cannot be have an adverse employment action for taking FMLA.
One teacher writes, "I was told this evening when I asked to return on Tuesday that I no longer would be able to teach in my same class and school." Another states, the district is retaliating against her by, quote, "replacing me with a substitute teacher who is not highly qualified or is not a certified teacher." Their lawyer tells us he believes all of this can be viewed as adverse employment action.
They tell a teacher, okay, you're going to move from preschool, which you've been teaching for the last 12 years, to 8th grade.
Have they actually done that, asked a preschool teacher to move to an 8th grade position?
Yeah.
ABC 15 reached out to the Queen Creek Unified School District with a list of questions. District officials sent us this statement saying the district is complying with its obligations under the FMLA, including its obligation to restore employees returning from FMLA to the same or equivalent position with equivalent benefits, pay, and other terms and conditions of employment.
The law says, we can't discourage people from trying to take FMLA. And I think all those employment actions are meant to discourage a reasonable teacher from taking FMLA.
In a school year that is anything but typical, Camunez says the last thing these teachers want to do is take legal action against their district.
They just want their classrooms back.
In Queen Creek, Sonu Wasu, ABC 15, Arizona.